Kedves kollégák, folytatnánk akkor a programunkat a kerekasztal-beszélgetéssel. A kerekasztal moderátora Balogh Tamás kollégánk a Közjegyzői Kamara részéről. Én őt szeretném bemutatni, és ő fogja továbbiakban felvezetni a kerekasztalban résztvevő kollégákat. Dr. Tamás Balogh is an expert of private international law. He has been working in the Department of Private International Law of the Ministry of Justice of Hungary for 9 years. He attended regularly the expert group meetings of the Council of the EU. In the first half of 2011, during the Hungarian EU presidency, he was the vice chair of the working group of the Council responsible for elaborating the European Succession Regulation. He works at the Notary Institute of the Hungarian Chamber of Civil Law Notaries, and his main task is to support the Hungarian notaries concerning the private international law issues. Since January 2019, this year, he is the Vice Director of the Notary Institute. I would like to say a warm welcome to all members of our round table, and I give the word to Tamás Balogh. Thank you.
Thank you very much. Dear colleagues, now we'd like to continue with our international roundtable. I warmly welcome our speakers, our guests, and I'd like to thank you all for accepting our invitation. I have the pleasure and honor to introduce you to our audience. First of all, I would like to start with the speaker on my right. Dr. Rembert Süß is from Germany, an attorney. He's a recognized expert of private international law. He's the director of the Department of Private International Law in the German Notarial Institute in Würzburg. He has published numerous books in the field of international corporate law and international succession law. I would like to highlight one of his publications that have been released under his editorial work. That is the Erbrecht in Europa, the succession law in Europe. I can say that we really like and regularly use this book in our Notarial Institute in order to find the adequate succession law provision of a certain European country. The president of our chamber, Ádám Tóth, and Tibor Szőcs, the head of the Notarial Institute, also contributed to the writing of the chapter relating to Hungary. And it's a real honor that you accepted our invitation and you are here with us today. Then I would follow on with Agata Żukowska. She's from Poland. She's an expert of private international law. She's a judge in Olawa. Now she works in the Ministry of Justice of Poland in the Department of Private International Law. She was the vice chair of the working party of the Council, responsible for elaboration of the European Succession Regulation under the Polish presidency in 2011. And the Polish presidency came right after the Hungarian in 2011, and we had several common meetings, discussions during the so-called trio presidency. Then I will follow with Stefan Matyik de Anjoni. He's from Austria, expert of the Austrian Chamber of Civil Law Notaries. He was the head of the Brussels office of the Austrian Chamber for 11 years. Then he was a legal officer, a seconded national expert in the European Commission at the DG Justice and Consumers for 5 years. At that time, he was dealing with the judicial cooperation in civil matters, and besides other tasks, he was involved in the elaboration of the form of the European Succession Regulation. And now he's in the Austrian Chamber of Civil Law Notaries as an international expert. Then Dan Andrei Popescu on my left. He is from Romania. He is a civil law notary in Cluj, in Napoca, in Kolozsvár. He is a professor at the Babes-Bolyai University. He teaches private international law, and he is half Hungarian, and also speaks Hungarian. Köszönjük, hogy elfogadta a meghívásunkat. And then, last but not least, Wojtek Kavecsanski. He's from Slovakia. He's a notary in Košice. He has been the Slovakian delegate of the European Affairs Commission, the CAE, of the UINL, the International Union of Notaries, for a long time. He's an international expert, the international expert of the Slovakian Chamber of Civil Law Notaries, dealing regularly with succession matters. Now, please allow me to present briefly the topic of our international roundtable, which is the practical operation of the European Certificate of Succession in certain member states. The application of the European Certificate of Succession, just like the application of the regulation, is 3.5 years old. 3.5 years old, this means that it has entered the kindergarten age. And I believe, and I hope you will agree, it's had only a few childhood diseases. I'm sure that all of you are familiar with the European Certificate of Succession. Some of you have already filled in the forms of the certificate, although I think it might be useful as a reminder to briefly review what the most important characteristics of the certificate are. The European Certificate of Succession is one of the greatest novelties, achievements of the regulation, a brand new legal instrument. It doesn't derive from the national laws. It was created by the EU law, a sui generis legal instrument, thus its legal effects are the same in all member states. It is an optional legal instrument. It is not mandatory for the heirs to use it abroad. They are free to choose to assert their rights abroad. Either the national instrument, the decisions already exist under their national law, or they can choose to use the certificate and present this in another member state. For instance, in Hungary, the heirs can use the decree on passing of the estate issued or made by the Hungarian notary, that is the hagyatékátadó végzés in Hungarian, or after this decree becomes binding, final, and absolute, they can apply for the certificate, and they use the certificate to assert their rights abroad. The regulation sets out general procedural rules for the issue of the certificate, minimum standards that must be complied with by the issuing authorities. The certificate is issued with the use of forms, standard uniform forms. All points are the same in all EU languages, and this helps the legal practitioners a lot to understand and interpret its content. There is one main form, which has 6 annexes. 5 of them is optional, and 1 of them is mandatory. It has to be issued and filled in all the time. That is Annex 4, about the status and rights of the heirs. Certificate can be issued only in member states whose courts have jurisdiction under the regulation, and the issuing authority can be a court defined by Article 3, Paragraph 2. Hungarian notary is deemed to be a court under the regulation, or it can be issued by another authority which, under the national law, has competence to deal with succession matters. The original certificate is kept by the issuing authority, and the issuing authority issues 1 or more certified copies to the applicant upon receipt. And these copies are valid for 6 months. And the greatest advantages, the greatest benefit of the certificate is that its legal effects are the same in all member states, regardless of the place of issue or the place of use or the place of the law applicable to the succession. It produces its legal effects in all member states without any special procedure being required. Let's see what kind of legal effects the certificate has. The regulation establishes a legal presumption the certificate shall be presumed to accurately demonstrate the elements which have been established under the law applicable to succession, and the person mentioned in the certificate as the heir or legatee or executor or administrator shall be presumed to have the status mentioned in the certificate and hold the rights or powers stated in the certificate. This means that the person mentioned in the certificate as an heir is presumed to be the real heir. Another important legal effect that the regulation lays down the protection of third parties acting in good faith through establishing the public faith of the certificate. If someone acting in good faith makes payments or passes on property to a person mentioned in a certificate as authorized to accept payments or properties, shall be considered to have transacted with a person with authority to accept payment or properties. In practice, the legal effect is the most often referred to. This legal effect enables the heirs to obtain money from foreign banks and obtain money from foreign bank accounts by presenting the certificate. The banks before which the certificate was presented is validly acquitted through the payment to the heir. And another very important legal effect is the legitimating function of the certificate in relation to recording of succession property to the registers. The certificate shall constitute a valid document for the recording of property in the relevant registers of the member states. The heir may ask for the recording his ownership rights through presenting the certificate to the register of a member state. But at the same time, the heir must comply with the formal requirements of the law where the register, the law of the member state where the register is kept. So now let's see how you think the application of the certificate has been going so far. How do you see it has been applied in practice? And now I would like to pass the floor to our speakers. I prepared with a few questions, but feel free to speak about anything you'd like, you come to your mind. Our first two questions I wrote down is, how do you evaluate the first 3.5 years of the application of the certificate? What is your experience? To what extent the certificate has replaced other national documents, national decisions? How often do the heirs use the certificate to assert their rights in another member state instead of other already existing documents? What is your experience in which member state the certificate is used in your country the most often? Is there any member state with which you have some kind of problem, or it operates really smoothly and easily? So I think, Dr. Rembert, would you be so kind to start with our discussion?
Thank you very much for the invitation here. I'm very impressed about this organization and this audience. So much people who are interested in the succession regulation. The European Inheritance Certificate quite resembles very much to the German Certificate of Heir, the German Erbschein. In particular, the effects which have been described by Tamás Balogh are very similar to the Erbschein of the German law, and therefore it is no surprise that the certificate is very highly estimated and very welcomed in Germany. As far as I know, there are not very much significant problems with the inheritance certificate. One side shows the acceptance of inheritance certificate issued in other states of the Union, as well as the issue of certificates by German authorities. In Germany, it's like the certificate of her, the inheritance certificate is issued by the court, and the application for the inheritance certificate generally is notarized by a notary. You can also directly apply for it at the court, but in most cases the application is prepared by a German notary. There do not exist any figures about the number of inheritance certificate issued in Germany, and but a lot of notaries already told that they have made an application for such a certificate, and they do not report about any particular problems. And there are also no figures about the use of the German inheritance certificates in other countries. I presume that they are mostly used in Spain, Italy, France, Austria also. And there's also an experience with Spain. Spain already accepted the German certificate of her, or the national certificate issued by the German courts before the entry of force of the European succession regulation. And as far as I heard, they also prefer the national German certificate to the inheritance certificate according to the European regulation. Maybe this is only a question of custom. They are already used to the German certificate. Okay.
Thank you very much for invitation. I'm also very honored to be here, and I can only repeat what the professor already said. I'm very pleased to be and to share the time with you and my experience. As regards the European Certificate of Succession, as far as I remember from the Max Planck Institute, which delivered before we started our negotiations some analysis, that document was tailored particularly for the countries like Italy, like Spain probably, I remember Italy particularly, which doesn't have national documents in succession cases. So because of that, in Poland, we have, like Germany, our national documents, certificates, and this means that European certificate is so not in a big use right now, or maybe yet, right? Because of the transitional provision from the regulation also, which means that the European certificate can be issued only after the succession of the person who died after 2015, August 2015. So we still have, not as many cases with cross-border application to say, oh yeah, we need this document, yes? Because also I think of the specific situation of Polish people. We are rather migration for workers, yes? So, but people accumulate still their estate in Poland. So it means that they don't need European certificate, yes, in case of succession. So yet in this situation. So as far as was asking my colleagues in court and notary, because in both way we can achieve in Poland the European certificate of succession. It can be issued by notary or in the court by judge. So as far as I have heard, they don't use it as much. Yes, so maybe 5 certificates were issued, but it's not a big and common used. But it's a future, I think, definitely.
Does it work? Yes. So also from my side, many thanks for inviting me to take part in this discussion and also to be at this distinguished place of the Lorand University. It's really a special place, I have to say. Yes, in Austria, after 3 years, I can report that we have made last year a survey on the functioning of the succession regulation among Austrian notaries. And I have to say that 25% of all Austrian notaries have replied to this survey, which is really quite good and I think representative. And from this survey we could deduct that 3/4 of Austrian notaries, so roughly 75% of all Austrian notaries, have at least issued one European certificate of succession since the application of the regulation, since 2015. So we have several hundreds of certificates which have been issued. As I said, at least one. We don't know exactly how many there are, but I would say that there are certainly several hundreds which have been issued so far. We are not aware of any major difficulties. There are maybe issues in particular relating to the translation of an ECS when it goes into a non-German speaking EU member state. So there is an issue that there is a need to have the content of the ECS translated into the language of the receiving member state. This is unfortunately, I would say, a difficulty, but you can hardly avoid it because, of course, the certificate needs to be understood also in the receiving member states. In general, I would say we consider it really as a big step ahead. With a lot, we have to realize that it's the first time that such a document with, as you explained, Tamás, with autonomous special content, procedure for issuing, and also own legal effects has been established by the European Union in the area of civil justice, and it is a big step, and I think it represents a lot of advantages for the citizens who use it. I can also tell you that in Austria, maybe many of you probably know this, in Austria the notaries have quite a similar position compared to the notaries here in Hungary. So Austrian notaries are competent for the succession procedure in their function as court commissioners. So they work as part of the court. However, the final decision is still with the court, but the whole procedure before that is done by the notaries. And in that context, the Austrian notaries are also competent for not only for preparing the ECS, the European Certificate of Succession, but also for issuing it. So in Austria, it's a competence which has been given to the notaries. Therefore, probably this explains why there's quite a high number of, compared to maybe to other member states, of European certificates of successions which have been issued. I think as you said already, the legal effect is really one of the main advantages. So compared to the situation before the regulation, I think we have now an instrument which should be used, and because it represents such advantages as having common legal effects, I think it cannot be underestimated. So all in all, the experience is a positive one. We don't have any particular issues with one or the other member state on this. We have rather problems concerning the national court decisions to get them circulated in other member states. That's more a problem, but less with the European Certificate of Succession. So, thank you. All in all, a positive, I would say, summary or resume.
Thank you very much. Please, Mr. Popescu.
Nagyon szépen köszönöm az invitációt. Az én magyar nem csak olyan jó, mikor kicsi voltam, csak magyarul beszéltem, na egy kicsit, de magyar érzem magamat, ez a fontos. About European Certificate of Succession, in my opinion, there are some problems. The best national certificate, in my opinion, is the German national certificate, Deutsche Erbschein, and I think it's much stronger than the European certificate of succession, because also the negligence of the acquirer of the property is by national Erbschein, it's how can I say, it's the European certificate is, the European succession certificate does not accomplish the negligence of the acquirer of property. The most complete national certificate is Deutsche Erbschein. There are some problems relating to European certificate of succession. So, I give some examples. According to Romanian law 206 from 2016, Article 3, the European certificate of succession shall be issued in accordance with EU regulation by the court, if it is a contentious litigation procedure, or by the notary public who issued the certificate or in the archive of which such certificate is being kept. In the event that, in my view, such an approach is deeply flawed and contrary to the principles of regulation. First, the two certificates of succession, national and European, are not in a relationship of dependency, are not in conditionality, each of which may be related separately from the other. The Romanian lawmaker attributing the competence of issuing the European certificate of succession to the notary who first issued the national certificate imposes in practice an additional condition not stipulated in the regulation for the issuing the European certificate of succession. Such a condition is contrary to the regulation and must be regarded, in my view, that unwritten and without effect. However, notarial Romanian practice complies with the provision referred above. Another question, in Romania, there are considerable number of individuals possessing dual citizenships, Romanian and Hungarian as well. Many of them choose by their last will, under Article 22 of the regulation, the Hungarian law as applicable to their succession. Unfortunately, the lack of knowledge of the new Hungarian civil code and related legislation, either by notaries or lawyers, considerably hinders the succession planning. There is no translation into Romanian language of the Hungarian civil code. On the other hand, there is no institutional relationship between Romanian and Hungarian notaries, which is absolutely necessary today, taking into account the large number of persons possessing the nationality of both states and wishing to opt for example, Hungarian succession law. I therefore believe that a cooperation protocol should be concluded between the two notaries and perhaps other notaries to create a permanent collaboration network. We do not have, as Germans, the German Notary Institute from Würzburg. I would propose to make a protocol and for designation of each national union of an expert groups providing for a fee a specialized advice and guidance. It might even go further in the sense that notary in charge of succession proceeding should convey the state of fact that it finds and for which he or she assumes responsibility, and that its resolution in law is ensured by the notary whose law has been chosen as applicable to the succession in exchange for agreed prior fee. The same support would also be required with regard to the fulfillment of the proceedings relating to registration of a European certificate in real estate register of the other member state. Some issues could arise, however, related to the name of the deceased referred into European certificate of succession is not identical to that of the plat book or Grundbuch owner referred into the land registry of the immovable property. This may be due to the differences that may arise as a result of transcription of the names in the civil status register, the difference due to ethnic particularities, the Romanization of names, or by contrary, the Hungarization of names, frequently occurred in practice. In such situation, it is recommended that prior to the issue of the European certificate of succession, a careful verification of the name of the deceased should be made as indicated in the birth certificate, in the death certificate, with the name appearing in the land registry. Another problem is related to identification data to the buildings or immovable property referred to in European certificate of succession are incorrect or insufficient. For instance, there is no indication of land book number, Grundbuchnummer, or the cadastral number, and this would be sometimes a problem because the identification of immovable property is used especially by Grundbuchnummer or the cadastral number, not just the street and number of this could be another problem. Of course, there is also a much complicated problem related to adaptation of rights. We saw also the European court practice, and I agree with some German experts like Christian von Bahr, Peter Mankowski, and Jan von Hein, who said that in his opinion, he is feeling that the European Court of Justice is trying to rewrite the regulation because it's if we see Kubica, Mannheim decision, and also Oberle decision. Oberle relates very special problems to the Latin notaries, those notaries who do not exercise judicial powers. We have here in Romania our notary public experts in our institute from Bucharest say, I'm not interested what European Court of Justice says about the European Court of Justice interpretation of Article 4, because we are not, do not include it in the jurisdictional norms of the regulation. And in my opinion, this is not really true, because the ratio of the overlay is to do not have secondary Erbrecht succession procedures. This is, of course, formally European Court interprets Article 4, but it is it's a further question, because a German court is obliged by the, for German court is mandatory the interpretation of overlay, yes, but for Latin notary like Romanian, Belgian, French, Spanish, Italian, they say, no, of course, I'm not exercising jurisdiction. I'm excluded from the jurisdiction rules of the regulation. And this is a real problem, because creates two kinds of interpretation and two kinds of view the relationship between European and national certificated succession. Thank you.
Thank you very much. You have touched a lot of interesting issues and problems. Yeah, you raised a lot of problems. I think we will discuss it, and if you have comments on this, just I will give the floor to the Slovakian colleague, and then we will come back to these issues, because yeah, Professor raised a lot of interesting questions. Please, Wojtek, the floor is yours.
Thank you for the floor. I will return to the first question about 3.5 years of evaluation of the certificate of succession, or European certificate of succession. I think in Slovakia there are not many certificates. I think more than in Poland, but not many. So we are just at the beginning of the whole process. And according to our experience in Slovakia, you know, the case is that in Europe we have more different legal systems and more different succession proceedings. And for example, when we compare with Hungarian law, with Austrian law, with Czech law, it's everything okay, but we face some problems, for example, from Germany, especially in real estate, because from Germany we used to receive certificates of succession without specification of the property. And according to our Slovak law, the property must be identified in such European certificate of succession. And if such certificate doesn't contain the identification of property, then our land register would not register it. It is returned back to the issuer, and he must correct it. So this is maybe the main problem of coming to Slovakia of certificates of succession. Also, we sometimes face problems from our certificate coming abroad, and usually the same problem is that our notaries are always, they do not know how to specify the property of, for example, from Austrian land registry, from Hungarian land registry, and sometimes this causes problems that the property is not specified precisely. So this is the main problems we face about European certificate of succession. Thank you.
Thank you very much. If someone would like to reflect on what have been said, please, Agata, there is a microphone.
I wanted to add some information for the mentioned question of jurisdiction rules and if they are mandatory for the notaries who are not the court in meaning of Article 3, Para 2 of the regulations, yes? So we will have soon a verdict, yes, because right now we have a preliminary ruling launched by the Latvian court. It's 80/19 case. And the question is exactly mentioned in that preliminary ruling. So I really sympathy with the questions because we saw the weakness in the regulation when we were trying to adopt in our national law some elements to make the regulation flying. And we saw that, well, we don't see our notary as at court. That's why we didn't make a notification as a Poland, but they are allowed to issue European Certificate of Succession. But we wanted to bound them by the jurisdiction rule and have this issue very clear for them, yes? And because of that, we bound them in our national law in a notariate act, obliging them to verify if they have jurisdiction in case of succession. Yes, so, and the jurisdiction rule are the jurisdiction rule from the succession regulations. So this was our solution to avoid such problems which are not clearly solved in the regulation, I think, yes?
But the point is, can your notaries issue national certificate of succession, not European? So there is a German court where it's the letzte gewöhnliche Aufenthalt, the last habitual residence of the deceased. And there are also some immovable properties in Poland. And can the Polish notaries issue national Polish certificate of succession, including the Polish property, not European, national?
Absolutely.
Yeah.
He has to follow the rule of jurisdiction bound, which are in the regulation also when he's issuing the national certificate.
Ah.
So we don't distinguish.
Yes,
we don't distinguish.
Yes,
he has to act in the same way, no matter if this is a national certificate or European one.
But
the same way as court is acting.
Yes, I understand. And this is an internal rule.
Exactly.
So,
it's internal law just to have a very clear way to act. Just not to make shopping in Europe for notaries.
Because you have just the opposite. So our notaries have possibility to issue national certificates of succession according to the Romanian law if they have property situated in Romania. That's a little big problem.
I understand.
Yes, I also agree. According to the Oberle decision by the European Court of Justice, the scope of the jurisdiction has to be interpreted in a very broad sense. So it will not only cover decision in the traditional sense, but also other acts which might be fulfilled by courts or might be fulfilled by financial authorities or notaries, like the issue of the European certificate of inheritance or other certificates of inheritance according to national law.
Okay. Yes, I would like to raise two issues, maybe also in the context of what you have said, Professor. The first is we have to consider the purpose, so for which purpose ECS is used. Depends on the situation of the parties involved. And the second point which I may which I would like to make, is to inform you about a decision from the Austrian Supreme Court concerning the use of the ECS in the context of land registers, the land register in Austria. So first topic, the purpose. I think, and there are more and more voices coming up, that this criteria of considering the purpose of the ECS is becoming more and more important now, since we have now more than 3 years of experience in applying the regulation. Because these problems, which are described, for instance, by our Slovak colleague, Kavečanský, I think since we are now in a situation where we have an autonomous instrument, the ECS is an autonomous EU law instrument, we have to think also in this dimension, in the EU dimension. And it cannot be, I think, that we produce or we issue ECSs which have no value at all for the people who would like, for the citizens who would like then to present the ECS in another member state. That means that we have a responsibility at the side of the issuing authority, but also at the side of the receiving authority to make this instrument work properly. So first of all, the issuing authority really has to inquire among the parties involved, the heirs or legatees or administrators of an estate, for what purpose concretely the ECS should serve. And according to that, some research, in my opinion, has to be done in order to really provide a maximum of information that is needed for the parties and to enable them to make use of the ECS in the receiving member state. So I would see the main responsibility with the issuing authority, but also there is a responsibility of the receiving authority, because when the receiving authority gets the ECS presented, it should not right from the starting point say, no, it's not enough. So that's why I think that's the challenge, that we have to make it work, to build the bridges between jurisdictions. And again, the purpose, I think, should be our guideline here, in a pragmatic approach, if you want. And we should not be like in a cage of the national systems. It cannot be anymore. So that's the first point, which I would like to make as a point of reflection. The second issue concerns the land register, and I would like to refer to this point, because we had comparable problems. Also, ECS is coming from Germany without a specification of the immovables, and which were then presented at Austrian land registers, and they have been refused because of the lack of some specific information, in particular the reference number of the real estate. Now, since 15th of May last year, there was a Supreme Court decision which I think helps us very much to solve this issue, because for the first time the Supreme Court, it was the first case on this issue, the Supreme Court explicitly spelled out that there is no need anymore to mention exactly this, the reference number and everything concerning the immovable in the ECS, and that the ECS can serve as a basis or as a document for the transcription of the register. I think this helps us tremendously in solving these questions and issues, not in particular concerning Germany. So there should be no big issues anymore, I think, because it was a case concerning Germany, if I'm not wrong. I think it was a case relating to Germany. So in my view, this was a big step also in the spirit of giving effects, trying to give effects, proper effects to the ECS in Austria. And it was in the spirit, I think, of the whole regulation to make it work. So I think maybe this is something which eventually could be followed also by other member states as an example. Because otherwise it was clear in this case at least that the parties requesting the transcription of the register, they had sufficient documentation in order to do that. But again, the exact reference of the immovable was not there, and it was still it was possible, according to the Supreme Court, to transcript it in the language. So this helps us tremendously, I think.
Thank you very much, Stefan. From the Hungarian point of view, I can confirm that the Hungarian legislator did that work, what the Austrian Supreme Court has just decided. Since the 1st of January 2018, it is not necessary to specify the exact assets and give all the numbers, the cadastral number and the numbers data necessary to identify a certain immovable in the European Certificate of Succession itself. It is enough to provide a share of the heir, what is the share of the heir, but at the same time the applicant, in the application form, which is a necessary requirement under the Hungarian law to submit an application form, the heir has to provide that information in that form, what is the immovable that is affected, that is concerned in a certain case. But in the European certificate itself, it is not necessary, it is not a requirement to specify the asset. So it has been done by the Hungarian legislator because of the German Erbscheins, exactly, and plenty of attorneys came to the Hungarian chamber and said that is a undecided situation because in Germany the court, the Nachlassgericht, cannot include the assets itself and you cannot specify it. It is under their German law that only the share is written there. So they could not solve this problem. Therefore, the Hungarian legislator solved it. So it is not an issue, fortunately, in Hungary anymore. Would you like to reflect on these matters?
I will reflect to the last change you mentioned, because in Slovakia we can arrange, or the heirs may arrange that one real estate belongs to one heir and the another to another heir. So how this will be mentioned in the certificate, European Certificate of Succession? Because if you have only share, you have now in this case you will have one real estate for one and another real estate for another person. So you must write which real estate belongs to one and which real estate belongs to another. Or how do you solve this problem then in your countries?
According to German law, that the Grundbuch, the register of land, which specifies who is the owner of a particular estate. For example, the deceased is the owner of the estate, and it's the inheritance certificate which certifies who is the heir of the deceased. And if you put both together, you know who is the actual owner of this piece of land. So you have to put them together, the land register and the inheritance certificate. It's also the opinion in Germany that the inheritance certificate certifies only who is the heir or who inherits the property of the deceased, but there is, it is not possible to state what is part of the estate. And we have two decisions of German courts, the Superior Court of Nuremberg and the Superior Court of Munich, who declined to state in the European certificate which is part of the estate.
Thank you very much. And if I'm not mistaken, the heirs can decide, heirs can share out. There is a sharing out of the estate. If they want, they can specify it, but that is not under the succession law. That is under the property law, and so that's another issue. So there is a community of heirs, but they can share the assets if they want. I mean, if I'm not wrong. Thank you. Okay. Thank you very much. My question would concern this exact topic what we have been talking about. There is an Annex 4 of the European Certificate of Succession, and in this form there is point 8 and point 9. Point 8 refers to the share of the estate of the heir to be specified, and in point 9 it shall be indicated, if possible, what assets are attributed to the heir. And under the law of your member state, which of these 2 points are generally filled in? Only the share of the estate of the heir, or you can specify the assets attributed to the heir, or is there a possibility to fill in both points, the share or the assets? I will.
As we know, the European Certificate of Succession, that form is not mandatory, it's orientative. But indeed, in point 8, Annex 4 of the European Certificate of Succession, the share of the estate of each heir is to be specified according to the law applicable to succession. This is the rule of thumb, or the most frequent case in practice. When there are several heirs, the notary determines the shares of each of them, specifying it in European Certificate of Succession. In point 9, it is rather a case of exception where either of these is only one heir, or the heirs agreeing to the partition, totally or partially, of the assets between them, on the allocating the exclusive ownership of assets acquired by succession. But this is not a very complicated question. In my opinion, there is also a great problem related to the fact that European Certificate of Succession is completed in a national procedure. This is the big problem. And I want you to emphasize that in Latin notaries publics, especially Romanian, but not just Romanian, when you issue a certificate of succession, being national or European, you finalize the procedure. So you cannot do this just when all the heirs are present to the procedure. And that's not the case of European Certificate of Succession, because according to the literature, the doctrine, and there are a lot of books written commentaries, Münchener commentaries, Caravaca, Mansell, Andrea Bonomi and Vautelin, a lot of others. And also we know about Article 35.1 of the regulation says that a certificate shall be issued open application by any person referred to Article 33. It's not mandatory to be all the heirs present when that European certificate is issued. And that's a problem, because it can interact with national law. Of course, it comes a legacy. And so I want a European certificate of succession, mention that I am the heir, the legacy of that immovable property situated in Germany. But and according to European succession regulation, it is mandatory to issue that European certificate of succession. But I do not know if that property does not affect the rights of other heirs. If the reserved heir of other heirs are not affected, so there is a problem of mentality also. Have I the power as notary to issue a European certificate of succession just in the presence of one of the heirs, of course, mentioning the rights of the others? Or it is mandatory, using national legislation, to be in the presence of all the heirs. That's a question of mentality. That's a conflictual, because European certificate of succession was minded as a very simple and useful and very certificate, but it seems to be rather an expanded national certificate of succession and not a very facile, very smooth procedure. Thank you, sir.
Referring to the question raised about the present or informing the beneficiaries, I will recall Article 67, para 2. The issuing authority shall take all necessary steps to inform the beneficiaries of the issue of the certificate. So, as far as I remember, we understood during the negotiations that there is an obligation to inform all beneficiaries of the estate. True, there is no rule that they all have to be present during the procedure, yes, but they have to be informed of the certificate, yes? As regards the Polish law and the Polish situation with Polish certificates, I will say like that. In Article 67 of the regulation, we have to remember that the issue of the certificate is possible only when the elements to be certified have been established under the law applicable to the succession. So what I understand in the Polish situation, if everything depends on the request of the heir, of the person who wants to have the certificate. If the request is only to certify a status as the legatee or the status as the heir, there is no problem to issue the certificate immediately, yes? Or if there, but it in case when the case is not disputable, yes, because the European certificate is not to solve the disputable case, yes. So this is very, very important according to my understanding. But if I will ask for the issuing the certificate for proving that I am the owner of the particular asset of the estate, being a heir, then it's not possible to issuing the certificate unless I am a legatee from the legatium per vindicationem, which is possible under Polish law, yes? But if I am just a heir and I am not the only heir, and I want immediately to have European certificate without sharing before the state in the court or by the notary deed, then it's not possible, because although we have ipso jure succession, so we can just declare that you have a status as the heir, but if you want to prove that you inherit particular assets and you are not the only heir, you have to go through the national case or go to the notary to make the sharing of the estate, yes? Otherwise, the facts are not established under Polish law, yes? Because the decision for sharing of the state is a constitutional kind of decision, yes? Because you are establishing, for example, that the particular assets belongs only to you, yes? So this must be shared by the national procedure, yes? So.
Yeah, just my question. This is a very sensitive problem, because if you, as a notary, for example, issue me a European certificate of succession, mention that I am the legacy of a immovable property situated in Germany, I go back in Germany and I register in Grundbuch this property, even if the other shares doesn't know that they were not present at the procedure. This is a very sensitive problem, because if you issue me that certificate that has a probative value also in Germany, and I can use it, and ich kann mich eintragen in deutschen Grundbuch, and after all I can sell that property. And
that's why, according to my understanding of the regulation, the notary who is issuing this document should at least inform the beneficiaries. So I will inform it's written in Article 67, Para 2. Okay. So for me, it's written.
I also put the procedure for the issue of the certificate is not completely described in the regulation. The European legislature mainly refers this work to the national law, and I only know the German law, and according to German law, every person who has an interest in the estate that are all the closer relatives of the deceased person who might have a forced share in the estates, or persons who might be beneficiaries by a will made by the deceased. All these persons have to be informed, and they have to be given the opportunity to object the issue of the certificate, and by this it will be avoided that an inheritance certificate or a European certificate will be issued in a case which is disputed between the person interested.
Thank you very much. The next question would be the fee of the certificate in your country. I would start with Agata.
We have, as I said, that the European certificate can be issued by the court, and the fee is 300 zlotych. So it's like, I don't know, 80 euro, more or less, yes. So it's cheaper than a decision in sharing of the state, which is 500 zlotych for undisputable case in the court, but much more than for the fee for a simple national certificate, which is just 50 zlotych, yes? So we have this 300 zlotych, like the same kind of amount we charge for obtaining the exequatur procedure for a foreign judgment. So we just make this kind of comparison, yes. And for the notarial deed, for European certificate, we have a maximum fee, which is 400 zlotych, which is like 198 euro, something like that, yes.
Oh, I see. There's good reason to die in Poland. In Germany, it's much more expensive. The fee for the European Inheritance Certificate is calculated on the basis of the value of the estate. And if the estate has a value of 100,000 euro, the fee is 273 euro. For 500 euro, $500,000, it's 935, and for 1 million euro, it's nearly 2,000 euro. And you further have to pay for the affidavit, because if you apply for an inheritance certificate, you have to make oath that the statements you made are correct. There is also a supplementary fee for that oath. And further, we have a fee for every copy of the European Inheritance Certificate, and this is close to the fee in Poland. This copy is 20 euro for each copy. Okay.
Thank you.
There is also good reason to die in Romania, not just to live, but to die. So I can also say there is more people alive today than had ever died in the history. That's a good news, because we will have a lot of work. Their succession will be opening. In Romania, there is just a small number of European certificate of succession, 87. That's not a lot. And the price for issuing one certificate, the cost is between 30 and 80 euro. It's not a lot. But there are also notaries who completing the national procedure, they does not take. They do it for nothing, so it's also possible. Because in my opinion, this mandatory national procedure and mandatory national issuing of national certificate of succession prior to European succession is illegal, in my opinion. Because there is not dependency between these two kinds of certificates, national and European. But the Romania, it's another way. Thank you.
Thank you. In Slovakia, the price or the fee for European certificate of succession is fixed fee, and it is 66 euro per one certificate. You must then, it's excluding VAT, and also there are some fees, so altogether it is like 90 to 100 euro per one certificate. Comparing to national decisions are usually more expensive because national decisions do not have fixed fees, but there is a percentage of the value of the estate. So it's decreasing percentage scale, but I don't know now the exact. It depends on the value of the estate. This is the case.
Thank you. I'm watching at the clock, and I think we have to finalize our discussion. But I realized that there are a lot of interesting questions, and we had a quite vivid discussion. And thank you very much for your contributions. They were really valuable, and I feel that we can talk for a really, really long time about these issues, and I hope we will in the future. but I don't want to steal the time from the very interesting case study solving issues and groups. And thank you very much for joining us and having this great conversation. Thank you. Thank you for your attention.